Denise, you want to do the honors? We will call the Rules Committee to order at 11 o'clock. This time, Counselor Taylor, would you please do the honor?
I will. Bow your heads. Heavenly Father, we're so grateful to be here today to do the work of the Cherokee people. We pray that you will guide our hearts and guide our minds as we make our decisions that would be best for them. We pray that you will be with people who are traveling today. Keep your hand of protection on them. Also be with our servicemen and women as they fight for our freedom. Go with us when we leave. For it's in your name we pray. Amen.
Thank you, Denise. Roll call, Shirley.
Joe Bird.
Ani.
Hannah Dudley.
Ani.
Keith Austin.
Here.
Charlie Buzzard.
Here.
Julia Coates.
Here.
Sean Crittenden. Joe Deere.
Ani.
Mike Dobbins.
Here.
Rex Jordan.
Here.
Daryl Legg.
Here.
Wes Snowfire.
Here.
Dora Petskowski.
Here.
Mike Shambaugh.
Here.
Mary Bakershaw.
Ani.
E.O. Smith.
Here.
Denise Taylor.
Here.
Victoria Best West. We have a quorum.
Thank you. The approval of minutes, they were mailed to you at this time. Entertain a motion.
So moved.
Second.
A motion and a second. All in favor, signify by saying aye. Aye. All opposed, ayes have it. Reports. Marshal Service, Shannon Buell. Well, he's been having a busy week.
Besides what's in my usual monthly report, we also have Marshall that's graduating FLETC this week. It's been a long 4 months for him. He's been physically beat up several times, which I have no sympathy for because I was too at that age. So, but he's done very well there. We've gotten nothing but good reports from him and his training staff over the last 4 months. So we're very pleased to get him back. He'll get back probably Friday, I'm guessing. Report duty next week, and then he starts 4 months of FTO. So even though he just spent 4 months getting beat up at FLETC, he'll come back just to get 4 months getting beat up by our people. So we look for nothing but good out of this officer. He'll go through learning now what it is to be a Cherokee Marshal for 4 months. And then after that 4 months of evaluations, that evaluation happens every time he comes to work. They'll evaluate his presence, his uniform, how's he shaving, how's his hair look, how his boots look, how does he answer the radio, how does he write a report. And these are evaluations that will happen to him every day, every shift. And then in 4 months, the staff gets together and decides, is he going to continue being a marshal or to be something else? So this 4 months is kind of high stress on the individual marshal because they've given up careers, they've given up 4 months at a federal academy in Artesia, New Mexico, which is not the most lovely place to be for 4 months. Let me throw that out there. And then the real process, the real tests actually take place for him starting next week. So he's going to have a busy 4 months. And it is our hope that he does well in that FTO and he becomes a marshal for us. So with that, if there's any questions you have, I'm more than happy to answer them.
Any questions for our marshal? Yes, Counselor Bakershaw.
Hi. Shaw work. Shannon, I have a question. It's not a question. It's more or less a comment. I've had a couple of people comment to me about the security at the new health clinic.
Okay.
Especially, I guess, in the evening, around the emergency area. They are there, and they're in bulletproof vests with guns. And they talked about how intimidating it is and that they're apprehensive even to go in, not knowing if something's about to happen or whatever.
They do not have guns.
Okay, well, I was told they did.
They do not have guns.
But if you could just ask them to smile and, I'm sorry, but you know, if you walk in and you're feeling really bad and you walk in and you see some guy in a bulletproof vest standing there looking around and all, I'm just saying it's intimidating to our
I
people.
can tell you, I do not supervise the security at the health centers, but I will let the security supervisor that does know that. But no, they do not have firearms.
Well, I'm glad, I was told they did, so, but anyway, if you could just, I'm just saying, when you feel bad and you're scared, and anymore you hear all these horror stories of things that could potentially
I will
happen.
call
And I
the
said I understood why they might be up there like that, but yeah, if they could just make people feel a little more comfortable, it would be nice.
Do we want our greeters to look really mean? How are we going to handle this of people that
That's why we don't allow marshals to greet people. They're not the best candidate for that. You know, there's other job descriptions that's good for that. But I would concur that security needs to, it's like our security here at the complex. If you notice, they do wear stuff that could be intimidating, but I can tell you, they always smile, they always greet people, they always have a good word. And
I like that. I like the way they
I do
handle
too.
it.
I
Yes.
like the way they look. So I will definitely talk to them, but it's probably not their status norm. From the people that I know that work over there are good people. They love what they do, and they love taking care of patients.
Well, I do want to share with you, I actually defended their stance on that they had guns, okay? I said, anymore, you never know what's going to come in emergency. I actually did, and now you're telling me they don't have
They
guns.
don't have guns. They have tasers, but they don't have guns.
Well, I was defending their right to have guns. So.
Well, I would agree, but they don't have.
All right. Anybody else? Good report.
Thank you.
Office of Attorney General, Sarah Hill. Good to see you.
First time I've successfully been here for a tribal council meeting since I was sworn into office. It's been busy time at the AG's office. I wanted to touch base on some of the things that I think are the sort of the higher priority issues in the AG's office right now. The gaming compact situation continues to, I'm sure all of you have been keeping up with it. Governor Stitt's office continues to maintain that the gaming compacts do not renew on January 1st for additional 15-year terms. The compact language is very clear that they do renew on January 1st for an additional 15-year term. The tribes and the governor have been corresponding back and forth, sometimes through the media, about their difference of opinion on that topic. The governor does have the ability to request to renegotiate fees and exclusivity under Part 11A and E, but he has not sent any proposal for what he thinks the fees or the exclusivity, how it should change, which the tribes have requested on several occasions now from him, so we haven't received any proposal like that. So it still continues to be a difficult situation. The AG's office is prepared. If we get drawn into litigation, we're prepared to protect the nation's rights and to protect our gaming operations under the agreement. So that's something that's definitely been a hot topic and at the top of the agenda at the AG's office. The other issue, which I'm sure you've all seen, was that the UKB recently had 76 acres of land taken into trust by the United States after a decision at the 10th Circuit, which held that Congress intended to allow other tribes to take land into trust inside the boundaries of the Cherokee Nation. And three judges on that panel in the 10th Circuit made that decision. We believe that decision fails to uphold and respect the treaties that the nation has signed with the United States. We feel like it misinterprets Congress's intent in language that it passed to protect the Cherokee Nation. And we will be requesting that the Supreme Court review the decision of the 10th Circuit. In the Murphy case, there was a development just on Friday in the Murphy case. The Supreme Court, as you might recall, has had a case in front of it over the Creek Reservation boundaries, whether or not the Creek Nation's reservation was disestablished. It took the Murphy case in the last term and then ended the term without deciding it, which is an unusual thing for the court to do, to issue no decision. But on Friday, the Supreme Court granted cert in another case called the McGirt case, which is very not identical, but very similar facts. A Creek Nation citizen convicted of a heinous crime inside the Creek Reservation. He did a pro se petition to the Supreme Court, and they have granted cert on that. The scholars, the people, the educated guessers who are looking at this situation feel like that the court accepted cert in that case because Justice Gorsuch can hear better. He was not able to hear the Murphy case, and a lot of people feel like that the court did not issue a ruling in that case because they were deadlocked 4-4. And they couldn't break the deadlock, and they didn't want to issue no opinion in the case or to just affirm it without an opinion. But McGirt, Gorsuch will be able to hear, and so that would give them a chance to actually make a decision in that case. So again, the Supreme Court doesn't explain itself to the rest of us peons out here in the universe, so we don't really know what's going on in their head, but that's the educated guessing that's going on by the different people that are keeping an eye on this case, including us. So we'll see what the court does in that. The other issue that we've got going on is the Brackeen case, which is the Fifth Circuit Indian child welfare case that I'm sure that you guys have heard about before in previous reports. The Cherokee Nation and the other tribes won an excellent decision from the Fifth Circuit upholding the constitutionality of the Indian Child Welfare Act But then the Fifth Circuit agreed to rehear the case en banc, which is to rehear the case with all of the justices of the Fifth Circuit, which was not a good development considering that the nation had won such a really resounding victory in front of the panel. So that case has been set for rehearing on January 22nd in New Orleans. That case will be heard in front of 16 of the 17 justices of the Fifth Circuit. There was a recent amicus brief filed by 26 of the states and the District of Columbia, states arguing that the Fifth Circuit should hold the Indian Child Welfare Act is constitutional, that they should overturn the lower court. And I'm proud to say that Oklahoma signed on to that brief in support of the Indian Child Welfare Act through Mike Connor, the Oklahoma Attorney General. So that was a positive development from Oklahoma. So those are the things that have kept me away from this meeting for the last several months, and which have been keeping everyone in our office extremely busy. I'll be happy to answer any questions that I can.
Any questions for our Attorney General? Yes, Councilor Coates.
Thank you. Can you explain again about your saying on the UKB cases that we are going back to the Supreme Court? I thought we had already approached the Supreme Court. Can you explain to me what the next move is that you just mentioned?
So everything that's happened so far has happened at the 10th Circuit. So the 10th Circuit decided the case. The Cherokee Nation filed a motion for rehearing en banc, like they did in the 5th Circuit, requesting that the entire 10th Circuit rehear the case, and that motion was denied. The Cherokee Nation requested a staying the mandate so that the mandate wouldn't issue and the land couldn't be taken into trust. That request for a stay was also denied, but we haven't filed a cert petition yet with the U.S. Supreme Court, but we
Okay,
intend
so I'm
to.
just incorrect. I thought that we had, so.
Right.
Okay,
That's the status of the case right now.
okay, thank you.
Okay, Councilor Shaw.
Hi. Sarah, I have a constituent who wants to be a surrogate. And I think I copied you on this letter, and Chrissy replied, but not exactly answered the question. She's needing the surrogate agency that she wants to work for wants a release from Cherokee Nation
Right,
that they will not take hold of the baby should she act as a surrogate for another couple.
right.
And she needs something in writing. Is that possible?
It is not possible. So what she's requesting is something from the Cherokee Nation saying that this child, once it's born, will not be considered an Indian child as to the Cherokee Nation. But until there's no way for us to make a pre-decision about a citizen's, whether or not they're eligible for citizenship. So we can't say that this child, if it's born, would never be eligible for citizenship in the Cherokee Nation. It could be, and as sometimes happens in surrogacy agreements, the surrogate ends up becoming pregnant on her own through a relationship that she personally has. And the child is born in different circumstances than what the surrogate agreement may be intended. So different things like that have happened in different cases. There is no procedure for the Cherokee Nation to make a decision about a child who's not even yet been conceived or born, but what that child's relationship would be to the Cherokee Nation. So we don't have any mechanism to do that.
See, this is a Cherokee citizen who wants the employment of something that they're capable of doing.
Right.
But we're not going to be able to assist that person
No,
for what her right
Request.
to have birth for a child. We can't do that. I'm
I
really
mean,
shocked.
she can enter into whatever agreements she wants to, and she can agree to have that child. But we don't have any mechanism to say that this child, if they applied, would never be considered a Cherokee citizen. There's just no mechanism for us to do that. And if we were able to do that, I would question whether or not we would want to do that, because in those cases, until the child is born, you don't know what the facts are in that particular circumstance. So it's much easier to look at those circumstances on a case-by-case basis and say, okay, this child's been born under the surrogacy agreement, this child, then those cases can be taken up by the registrar or other people who can make that decision. But the AG's office is not in a position to define the rights of a child who's not yet born.
Okay, good. Yeah, Councilor Deere.
Hey, sir, how are you?
I'm
Good
doing
seeing you again. With the gaming compact on January 1st, do you foresee any problems dealing with vendors?
I mean, it's hard to predict what Oklahoma might do. I mean, I think that it's definitely possible that it's possible that they could decide to try to interfere with the vendors in some way. All I can say is that if they attempt to do that, we will take whatever legal recourse we have to protect the vendors who work with the tribe.
Yeah, because that's what I was wanting to know, if we had an obligation, obviously, to protect those vendors.
Yeah, I mean, if someone's trying to interfere with the business of the Cherokee Nation, then we will do what we have to do to protect our business interests legally.
Okay. Yeah, because I know a lot of them are tarot vendors,
Right.
so.
Right, and it interferes with the business. If the business can't get the things that it needs to operate, then it causes problems. So if the state begins to interfere in those business relationships, we'll definitely take a hard look at what our legal options are.
All right, thank you.
Yes, Councilor Shaw.
Yes. In regards to the gaming compact, do you see any possibility of perhaps bringing in sports betting and paying a higher percentage in that, and then remaining, keeping the gaming compact as is?
I mean, that's been bandied about in the media about sports betting. The governor's talked about it on a few occasions, but I've never seen a proposal from him saying this is what we would propose. This is something we would offer the tribes, and this is what we would want in return. He's not made any specific proposal like that.
Counselor Buzzer.
Sarah, I got an email, and I think some of the other councilors got an email from the Oklahoma Department of Rehabilitation Services, and they said they had sent this for an opinion to the Attorney General, but I don't know when that was done. Are you familiar with that? It has to do with disability from a health department to, and I take it to send records to this Oklahoma Department of Rehabilitation.
I'm not aware of
You
that.
might want to check that, because I'm going to bring that up in the health department, and I talked to Dr. Jones about it, and they were going to give an overview of what's going on there.
All right, I'll get with Dr. Jones and find out.
And what I hear from most people, they go up and they can't work, and I know the doctors, our doctors are not going to say, well, you're 85% disabled. But what I understand, the Department of Rehabilitation Services is not asking for that. They're asking for medical records, and we will not release them on electronic signature. So that's what the problem is what he's telling us. So you might want to take a look at it, because they said they had it sent this to the Attorney General and hadn't got a response back, but Dr. Jones and Dr. Montgomery hopefully will discuss that in the Health Committee also.
Thank you for bringing that to my attention. I'll
You're
definitely
welcome.
look into it.
Thanks, sir.
Yes, Counselor Legg, do you have a comment? No. Anybody else? You know, Sarah, I've been really encouraged about the people that's weighed in on support of our tribe in the gaming compact. You know, you're going back as far as the former governor that actually signed the compact, Brad Henry, and he knew the intent. You know, when I was in office, I signed motor fuels compact, tobacco compact with Governor Keating as well, and Governor Keating even weighs in. And you know, then you have all these former attorney generals for the state. Our former chief, Ross Swimmer, weighed in and said, you know, the compacts automatically roll over. And this guy still just doesn't get it.
Well, no, last week on the House side, the Speaker of the House sent out a document to all the House members which talked about the fact that even back when the compact was originally signed, there were documents from then that say that the compacts will automatically renew. So I think that the tribe's legal position is extremely solid. It's very clear, even just looking at what they call the four corners of the document, just looking at the compact, it's very clear that the compacts will renew. And I can't explain, but it has been heartening to see that a lot of people have weighed in, you know, on behalf of the tribes and said, yeah, that was what the intent was. And it's been, makes our lives a lot easier when everyone's looking at it and everyone reads it kind of the same way.
It does. This is probably the most united that we have been in a long time, the tribes, and that's good, because we've got big issues out there that we need to face, and it's time we do unite. So
It's if people wanted to, people who want to damage tribal sovereignty probably shouldn't pick fights like this with the tribes, because it unifies them, and that creates long-term consequences when any country gets unified this way.
well, as a sovereign tribe, that means we always have to fight for it.
Right.
Thank you. Anybody else? Good report.
Thank you.
Gwen Terrapin?
Happy holidays.
Merry
It's feeling more like Christmas now, huh? So far, we've got 38 total FOIA and GRA requests. We had a new one come in since the report was sent to you all and since the website was updated. And that's all I have for now.
Okay, you're doing a good job. You got us caught up. Anybody? Good report.
Thank you.
Sharon Swepston does a good job as a tax commissioner. Didn't even got on stage Friday and entertained us a little bit. Good voice.
Oh, good morning. I believe you have my report. If you have any questions, I'll try to address them.
Any questions for our tax commissioner? Good job. Did you have questions? Yes, Councilor Ross.
The Catoosa Agency, the new building that's being built, do we have timeline on that yet?
I do not, I know I went over the plans with the architect and stuff just a few weeks ago, but I haven't seen anything back. I don't know if Todd has or not. Have you?
We did provide feedback to them based on their initial site selection, and placement on the site, as well as the components inside the building. They are going back, reworking those based on the suggestions and recommendations from Sharon and her staff. I'm hoping we'll have a set of plans to roll forward at the first of the year. I will say that the lead architect on that particular project, his mother's been terminally ill for a while, and he's been a little bit hit and miss, but we sent an email on Thursday or Friday and indicated that they would have something back to us.
So any expectation of when we break dirt there?
I'm hoping sometime January, February timeframe we'll announce the groundbreaking.
Great. Community will love hearing that.
Yes.
See it happen.
Thank you, Todd.
Okay. Anybody else? Keep up the good work.
Thank you.
And you're invited for lunch tomorrow. Yes, Gaming Commission, Janice Purcell.
Good morning.
Morning.
I submitted my report.
Hey, everybody got her report? Questions? Yes, Counselor
I
Taylor?
would just like to request a copy of the schedule for the meetings for 2020 as soon as it's available.
Yes, and that is available. As of the last meeting, we did have it confirmed.
Okay. I'd
And
like
so
a
I
copy
will
of it.
have that on there.
Okay, thank you, Janice.
Okay,
That's all I
Counselor
have.
Buzzer?
Yes, Janice, I'd read your report, and I got a call over the weekend about why we pulled out of these two organizations. It wasn't in your report, that we pulled out of the Oklahoma Travel Regulators Association and also the INTGRA organization. Why did we pull out? And I'll tell you why they called me. Well, first of all, did we pull out?
No, we did not. We still have paid dues for this year, so no, we did not pull out.
Well, good, because after this person called me, he said, he went on to explain that he really hated to see the Cherokee Nation pull out of these organizations because we're some of the largest tribes that had been in this organization. We had a lot of a clout as far as having large tribes, and they were from a small tribe. So I don't know, I will get back to him and see why he told me that. So glad to hear that. Thank you. Thank you, sir.
Okay, anybody else? Yes, Counselor No Farm?
I think you was referring to, Counselor Buzzard. Was there, I guess, maybe an email that was sent out saying that our staff or our gaming commission staff will be going to these meetings, and if they do, it's on their own? I think before in the past that we used to send someone from our tribe in the past, haven't we?
Yes.
Okay, and are we still doing that, or are we now just making that kind of like an elective travel? If they want to go do it, they can take vacation time, otherwise.
In order to defray cost, we are not going to go every quarter. So we're not going to go 4 times a year to out-of-state conferences. Recently, we did for training, because the compact requires that we be trained, had training streamed for free from NIGC. And it was on the most recently required Title 31, which is compliance with money laundering, and also with the new FBI requirements that are in here for licensing. So in order to put our money with employees, equipment, things that we need, we're just cutting back on travel. We're not going we're not sending 10 or 12 people every quarter, which would be 4 times a year. So we did not pull out of those organizations. We are still active in those organizations.
Are we sending someone once a year, I guess, or sending a staff once a year up there to
That
our
is
position
what,
and understand what? Because am I correct? Like these associations they're compiling of tribes together to try to unify everybody's gambling associations together, so that way we all are in agreement on things if there was ever any kind of issues with the National Indian Gaming.
One of the organizations, the national one, only has 10 Oklahoma tribes.
Right.
So if we were to go to NIGA, that has more tribes, and we would get more information from those organizations. The one in Oklahoma, we still actually went to the national, not the national one, but the state one, which was in Tulsa, and actually we sponsored it. So we are, and that was in the last week of October. So we're still active in that, and we still are going to be training and keeping abreast of the new information that comes for regulatory.
Right.
So we will still send somebody to
Yes.
at least once a year.
Yes.
And take care of the travel.
Yes.
Okay, all right,
All right. I appreciate it.
okay. Yeah, I was a little misinformed on that as well, that we were just pulling out and not paying for anybody's travel expense.
No, we're just going to be more cognizant of the fact that the funds should be used in, in keeping in mind Mr. Bezzard, what he has said about, watching our money. That's what we're trying to do.
To be actively involved in NIGC level.
Yes.
Okay. All right, anybody else? Are you good with that?
Yeah.
Okay, anybody else? All right, good report.
Thank you.
Human Resources? Mr. Mason?
Good morning.
Morning.
Morning, Nathan.
I've submitted a written report. Most of our day is just finishing up on projects for the end of the year and trying to keep up with the amount of growth we're going through as a nation, making sure as quickly as possible the jobs are in place so we can fill all the positions. Anyone have any specific questions or?
Anybody for your questions for Mr. Morton here?
I have one question.
Yes, go ahead, Councilman.
I had a constituent apply for a position, and it's been probably over a month, and she hasn't heard anything. The only thing she heard is when she called the office that it was in process.
Okay.
And it was, I think it was a family advocate position or something, but it was just, there's like no communication, just, it's out there. Is there a time frame usually that they try to get back?
What we try to do is contact as much as possible, but our main thing with the automated system is when it has been filled.
Mm-hmm.
Because to get them all done, we're working on a way to keep the candidates informed of the process, but the primary goal is to work the file and get someone in. But we are trying to figure out some way to quickly and efficiently get an automatic update going, hey, it's still pending, we haven't forgotten you, or stuff like that, to go as an automatic email. But on step one, we try to fill the actual position, and once it's offered acceptance, we send something out at that time. But we're working on a way to get more contact throughout the process.
Yeah, I just know that sometimes there's a process when reviewing people, received, processed, pending, or you just make a cut, and then denied. Some kind of response, so.
Yes, I need something.
It just seems sort of
before that.
open-ended, yeah.
And I can follow up with you on the specific rec number or the person. I'll contact you
That's
after
fine.
this meeting.
That's fine.
See what it.
Yeah, thanks.
Okay.
Anybody else? Yes, Councilor Smith?
When somebody makes a panel, for the interview there, and they don't get the job, we still don't notify them, do we?
Not immediately. And the reason we do that is we suggest the department will set, give me your first choice. If something happens to that, give me your second choice. So I don't have to start all over again. They've already interviewed and have the panel. So if the first selection is made, that may not actually be the person that actually is made an offer. Either they have a job somewhere else or they decide not to go with our job. To save time and be as efficient as possible, what we're trying to do is to get as many that you want in that position, and if something happens with the first person selection, you can go to your second selection. So we avoid sending out the notice once there's a selection because we don't want everyone to think that that job is gone. Or make them have to reapply over and over for the same job.
Well, it'd save a few phone calls, you know, like if after they officially start work, if we could just maybe give that 4 or 5 a call and say, hey,
Been filled.
yeah, didn't been filled, you
Yes.
did good, keep applying, or something like that, instead of them calling, seeing them at work, come by and say, well, I wasn't notified or anything.
We will send one when it's filled.
Uh-huh.
But at the same time, if there's a qualified applicant that maybe didn't get that position, there'll be another one in place somewhere, so we try to have the recruiter give them a call.
Okay.
But yes, right now, it's the best we can under the circumstances, but we're trying to figure out a way to be more efficient and to where it can all do as automated as possible to get them contacted as well as fill the job.
And you know, that automation is good, but I doubt if those people who are I'm raised would
I'd rather have a
benefit
phone
by
call.
that. In rural Bellefonte, they can't even spell automation, most of them. They don't know what it means. So I'd like to, a phone call or a letter would really go well there. In certain places, you know, like Tulsa area, Rogers County, where everybody's got more access to computers, so forth. Now, there's where it'll work. But when you're in Dry Creek and Marble City,
They ain't got cell phone service down there.
there you go. Yes, Councilor Chris.
Yeah, I was just gonna say, when the conversations happen, I get a lot of calls where they're just kind of hanging on, and if we're just kind of leaving them out there until it's convenient for us, and I know that's not what you're doing, but it kind of seems like it to them. When the discussion, it's not just Mr. Smith, and I wanna
And
say that's
we recognize it too. We're trying to figure out a fix, a nice balance between keeping contact and getting them on board. Because you'll get a call the other way too if we don't do the balance right. Right now, my balance is there's not enough contact to applicants. So recognize that we're working on it.
Okay.
Okay.
Thank you.
At least you're working on it. Okay. Todd?
If I might just add to what Mason reported a little bit more, we're about to embark on a process of what we call process redesign for HR. And so it's a way for us to make sure that the resources, the money, the staffing, the systems that we have in place are aligned to help our HR team get the right candidates in place quickly and efficiently. And so we hope to kick that process off in January, wait until after the holiday season gets through and everybody gets vacations and time with family, and then we can start this redesign process in HR. It's not saying that staff's doing a bad job, it's just we want to make sure that we've given them all the resources and tools to do those jobs effectively.
Sure. You're doing a good job.
And so we should have a lot more information on it at the next meeting in January.
Okay.
On
Councilor
how to
Deere?
process short-term goals, long-term goals.
Yeah, the reason, Todd, that I bring it up is if that process is so long in this economy, and you have a good Cherokee citizen with everything you need, you don't want to lose them to the private sector.
Yep.
And I think putting it off a month and a half, you're talking 6 weeks of income,
Yep.
and they will get snagged.
Yeah.
So we have to move forward to that.
With unemployment practically being no unemployment
Right.
in the region, we have to compete and vie for those high talented, high
Right.
quality employees.
And I think communication is definitely necessary. So, thank you.
Good?
Yep.
Good report. Thank you.
Thank you very much.
Okay, dropping down to old business, Councilor No Fire.
This is an act amending Title 10 of Cherokee Nation Code annotated to preserve, protect, and incorporate certain Cherokee tribal traditions, customs, and culture. Kind of a little bit more about this. I know we discussed it last week and going in this month. This really affects the reason why I'm bringing it here is we have some elected officials. We've all talked about culture and tradition, whether it be language or other practices, and family structure in our clan system as part of that culture and tradition. That's why I've introduced this bill, is to protect our culture and tradition, which is an important aspect to some of our family members in our tribe. And it's necessary for our courts in instances to conclude this is having a credible testimony, a Cherokee elder that can come in there and verify that our families operate and live off this lifestyle. And I know we support National Indian Child Welfare Association along with NCAI. And they give a backbone to our tribe on a national level whenever dealing with instances such as like ICW. I'd like to read just kind of a quick thing off directly from NICWA's website, and that's dealing with our effective leadership aspect of it, and it just simply states that the heritage of child protection. It's until recently our natural helping systems were the primary approach to protecting tribal children that relied upon tribal culture, traditions, and extended family networks. The existence of extensive family networks meant that children were never left without care or orphaned after losing a parent. And that is the important aspect of this bill, and I make a motion for its approval.
Motion?
Second.
Second. Discussion? Dora, did you have a?
I would like to make a motion to table this piece indefinitely, just because I feel that we really need to do a little more homework about this.
You want to do a little bit more discussion, or you want to? Yeah, I know, but I'm asking her. So.
No,
You want to
not
just go?
today.
Second.
Okay. Got a motion and a second to table.
We get it. Point of order. Under Robert's Rules of Order, to table indefinitely effectively kills the bill, and I wonder if that is what you are in fact intending to do, or if it is simply to table until a later
I'd like
date.
to have Tim. Would you come to the front?
Also,
You and Sarah.
discuss the tabling aspect of it. We can discuss that.
I know we got a motion.
And a second.
Yes, and a second, and we hadn't voted on it. This is what I, been reading and looking this and getting comments. I thought we were going to take this back and make the appropriate amendments to satisfy all parties, and it looks like we have not done that yet. Indian Child Welfare, I don't think has weighed in on it, and I don't think. Sarah, Tim, which one do you want to go first and just briefly go over this? We're not going to spend an enormous amount of time in it. We'll take it back and either vote on it or we'll say, go fix it and bring it back.
Well, I'll just mention, we sat down, Wes and I sat down with Chrissy after the last council meeting for over an hour, and we agreed to withdraw certain parts of it. I mean, that she had concerns about. Effectively leaving it with that you have tribal elders that are going to be allowed to testify in tribal court, and that was going to be the primary component that was going to be left in the legislation. So it was my understanding that we were at a point where there was a consensus until I believe Chrissy sent an email out bringing up several issues that seem to go back to the prior version, specifically regarding something about overriding parental rights, which that had been removed. So I wasn't sure, where her email was going with that, and trying to determine what the intent of the legislation was. And again, I think we've been very transparent in our discussion with Chrissy. There was a lot of she kept trying to figure out what our our underwriting desire was with the legislation. And we kept trying to tell her, we just are trying to preserve our culture. We're trying to recognize that, we do have a clan system and that we, also have, elders that should be allowed to testify in court. And so I think, it's one of those things that she's like, well, sometimes elders are allowed to testify in court. But I think, what we were trying to do is say, hey, elders should always be allowed to testify in court. And, whether or not somebody's an elder can be determined by the court, or whether or not they're qualified to testify in court. But it's one of those things that we should be allowing, elders specifically to testify about Cherokee culture and tradition. Some of the things that she had presented were amending it to allow testimony on any Indian tribe. And my recommendation to Wes was, okay, that's getting it so complicated. How is a Cherokee district judge supposed to understand who qualifies as a Kiowa elder or a Cheyenne Arapaho elder? Or, think about how many different tribes across the country that there could potentially be a child within our jurisdiction. And specifically, this is just about preserving Cherokee culture in the Cherokee courts. And I think we just want to keep it simple. I mean, we've tried to keep this very simple and not overly complicate things. I think that's ultimately what we've accomplished. I think some of the concerns are more what if. And I think the problem with what ifs are there's so many what ifs. If we're going to consider what ifs, it would effectively disable this council to be able to legislate. I mean, every time we consider legislation, if we're going to what if this happens or what if this happens,
That's right.
we wouldn't be able to legislate because of all the what ifs. If there's issues with the court, we can come back and amend it. We have, my understanding is Wes has consulted Indian Child Welfare. We made those changes. I'm not sure why it keeps being said that Indian Child Welfare hasn't been consulted because, I know that I made there were certain changes at the beginning on the first version that incorporated changes requested by Indian Child Welfare. And so, specifically going to the courts, this is very, like I said, very simple. It's just, are we going to let our elders testify in court as experts? Because, as everybody knows, experts can give opinion testimony, whereas most people can't. You have to give first-hand knowledge testimony. And so, if you have a Cherokee elder come in and they don't know this child, somebody the opposing attorney can object to that testimony because they don't have first-hand knowledge.
If we utilize our elders as expert witnesses to testify in our tribal courts, can our opposing attorneys use the same request and have them testify in state courts?
If they have been qualified within tribal court as an expert, I would think that they could. But that was specifically the issue that Indian Child Welfare brought up, was whether or not a state judge could determine whether or not somebody was a Cherokee elder. In that case, it's specifically included in this amendment that Cherokee Nation can always intervene in any determination of who and who is not a Cherokee elder. So I think that was effectively reserving that right exclusively to tribal courts.
Okay. Sarah?
Well, I submitted to the council my thoughts on it in writing, so that's probably the best way for me to communicate with people is in writing, so you can look at that and see my thoughts on it. But I will just share with you that, I've been involved in hundreds of cases, in child welfare cases in tribal court and in state court in Oklahoma and in other states. And this is a tremendously complex topic, and the interplay between tribal court and state courts, all these issues are complex. And I think that going back to the drawing board, having real collaborative discussions with Indian Child Welfare, with the judges, with the Indian Child, I appreciate the thought that's going into this, protecting
I do too.
the clan system, protecting our elders, giving them a voice in our proceedings are all laudable goals. But elders testify in our tribal courts every day about these issues when they have relevant information and knowledge about the topic. And I just think that this needs to go sort of back to the drawing board and have another discussion about what are the real, and I think the ICW workers who work with these cases in state courts every single day are going to have some really good input about what are some of those. They're not what ifs if they've happened. And we have thousands of these fact patterns that we've worked through and these conflicts we've had in court. And you have access to all of that knowledge and information at Indian Child Welfare. So I definitely appreciate where you're coming from with this legislation, but I do think it kind of needs to go back to the drawing board and reevaluate whether this is really, whether this is the best way to accomplish the goal that you set for yourself. And that's just my opinion, which you're free to disregard.
Sure, yeah, and you'd be all right with that?
Well, I definitely would like to say that one thing that's important here is that what Ms. Counselor Paskowski and Counselor Austin brought up is they want to effectively kill the bill. They don't want to go back and actually rediscuss it. They want to kill the bill.
Yeah, and that's why I'm saying, are you okay if we allow the appropriate entities to go back and discuss it and bring it back to us?
Yeah, I think that's great. I think that's a great idea. From where I sit, I don't see what would hinder this bill being passed, what would stop anything of what's currently being done with ICW for us to build upon it. I think one thing to point out is that, and I appreciate our AG sending everybody an email, but their goal of the AG's office from the administration is supposed to be putting a legal opinion out there, not policy opinions. This is policies. And them weighing in on our council to try to affect our minds may hinder what the Cherokee Nation is about, which is 3 separate branches of power, and us as a legislator operating independently. So that's just kind of where I feel on it. But I do think that, yeah, this is a great topic. I think that if we need to go back to the drawing board and that's what this council feels needs to be done, absolutely.
That's what I would
as long as I want
recommend.
to keep moving it forward.
Well, we're trying to move it forward.
Right,
That's
exactly.
what I'm trying to do.
All right, so am I.
Okay, yeah, Counselor Kate Duncan.
That's exactly what I was going to say. I appreciate where you're coming from with it. Should elders be able to testify? Absolutely. But I'm hearing that they can, and now I'm hearing that they can't. And so, you know, in order for us to move forward, I think that we should probably discuss this some more and not just, you know, do a dry vote and let's get this passed and not know what we're.
If the council would agree to that, then let's do that. Is everybody in agree with that? Take it back to appropriate parties. AG, Tim, welfare. No, we don't. We hadn't voted on
That's
it.
the other thing was I got calls from ICW management and staff of their complete opposition to this, and that would be detrimental. And so I'd like to hear. I want to know why. I want to know why, and I'd like to hear from them. Those folks that work on the front lines every day with this. I want to get their input.
Well, and I personally went through, you know, dealing with ICW whenever we started our adoption process, and that's where, you know, I seen the need for culture and tradition to be included in on it.
And that's what we're trying to do. And if the council would be in agreement, I know we got a motion, you got a second, but if the council would be in agreement, we would take it back to the appropriate parties. Are you in agreement?
Yes.
Yes.
But I
Okay.
would like to say one more thing.
Go ahead.
I just want you all to understand that in order for a qualified Indian child welfare expert, there are 2 parts to that. Number 1, they have to have the cultural knowledge. Number 2, they have to have completed a competent child welfare investigation. Elders may very well help the case if they have case-specific facts, but an elder testifying will certainly not check the box of a qualified Indian child welfare expert unless they also happen to be trained in child welfare investigations and somehow have access to previous DHS, ICW, CANIS confidential records. Okay.
Yeah, well, I have all the faith that our people can implement the criteria that you just mentioned there. But again, back to the council, if you're willing, we'll let the appropriate parties go back and resolve this and bring it back. I don't want just an up and down vote. I mean, it looks like it's a good legislation, but I still got some questions myself. And we've got a very, very important case that was just mentioned here earlier. It's going to be in New Orleans, January 22nd. And I don't want the 10th Circuit, who has not been a very good friend of ours here lately, to take a look at this and say, what are the Cherokee Nation people doing? You know, they can't get their act straight on policy about Indian child welfare. And that's just my stance there. So if you guys would support this, someone make a motion, we'll take it back and let the appropriate entities do this.
Speaker, I think you just need to get the 2 motions to withdraw.
Okay?
Would you withdraw your motion?
Effectively you have, but I think for the record it'd be better.
Yeah.
Are you good with that?
Yes, I am.
Okay, thank you. Are you good with that?
I'm good with that.
Okay.
I just want to say one thing before I agree to that.
Okay.
as this council sits here and we talk about elders, we hold high regard our elders. Now, I think of just a trial recently that this elder was not allowed to give his testimony in court. And I think this is what it's all come from. So if we're sitting here, we all want to do good for the elders and respect the elders and stuff like that. I think we need to move forward at some point in time.
Yep.
Now, if we want to wait till after January, I'm fine with that, and so I'll withdraw my motion
Okay.
for that. But I think we need to put our thinking where our mouth is, because we're always respecting the elders. And here, we're having question marks about respecting those elders. So I just want to say that for the record.
Okay.
Thank you.
Well, we got a bunch of discussion. We got a lot of people who want to say things, but I've asked you several times.
Everybody want to speak again? I mean, I thought we were going to take it back to committee.
I have to do that.
Go ahead.
Yeah.
Yes.
Thank you.
I'm next.
Now, some of these questions, like I send it to Wes, or send it to Tim, you know, then there's discussions with other entities. So, like, if we have questions between now and when we're gonna talk about this again, would it be okay to send it to you, copy you, and someone give a plain English answer to the question? You know, because sometimes if I ask Tim, then we come here and hear a whole lot of other sides. But to get my question answered, I'll just send them right here and include Wes, right? And I can get a clear answer back.
As clear as lawyers are capable of, Councilman.
I think you'll get two perspectives, which should cover most of it. So I think that's going to be the most comprehensive answer that you can get.
What's a fair time frame to get a question answered?
I would say 2 days.
I always give emails from the tribal council the utmost attention, so I'll return it around to you as quickly as
I mean, because I've got a lot of little questions that we won't take time up here, but just before we talk about this, I would sure like to get some things clear. So I'll expect some from me, probably everyone else.
Have we tabled this or have we not?
Everybody's.
No.
That's what I'm saying.
Yeah.
He's got
I
to
gotta- I
withdraw,
gotta ask
correct?
Are we good? You want to make us?
Yeah, I'll make a motion to table until further discussion.
All right.
Okay.
That is
Steve,
absolutely
second?
not right.
Second.
You want to say something?
I did.
Go ahead.
You've already made the motion.
Well, there's a
I asked
I
you
really
to-
Well, wait a minute. I got the
Now,
floor.
let's go on.
Well, no, I got the floor. There's a motion and second. You want discussion? Go ahead.
My piece, I guess, in this is this. To say that an elder can't testify in a court proceeding is not right. I don't believe that at all. Anybody can testify in a court proceeding. You know, what you're doing is you're talking about something between the person who's presenting the case to the court. You know, that's who needs to, if we're gonna include people in this discussion, have a suggestion, and we need to talk to those people too and find out, is this a common practice to not let elders testify? I myself cannot believe that. I just have a hard time believing that anybody would be excluded to testify. And as far as being an expert witness, you still have to prove, if you have an expert witness, that that witness is an expert in that field. Doesn't matter, you just can't say, poof, you're an expert. You know you have to prove that. There's things that, you know, I do think it's a good thing, but again, there's a lot of things that don't really add up to me either as far as the problems. You know, obviously we have a court case coming up, but I haven't heard from Indian Child Welfare, and I would like to hear from Indian Child Welfare. That is a big deal to me, but I know in the judicial system how things work, and this really doesn't make sense to me because anybody can testify in a court. You can't.
But some are allowed and some aren't. Just
Well, but that's not.
And
but
just to
that's
clarify,
not-
I mean-
But that's not about something that we change, saying that you have to do this as a prosecutor. I mean, that may be where the communication comes in, saying, well, you know, we have information that some people aren't allowed to testify. If so, why is that?
Was
So
that
we
in
don't-
tribal
We
court?
don't. That's
And
not.
specifically, you know, Councilmember Kowski specifically gave the one limited instance where a person, whether they're an elder or whatever they may be, can give opinion testimony. Fact testimony and opinion testimony are the two different kinds of testimony. You have to be an expert to give opinion. So if you came in and you gave testimony as to what is the tradition or culture, you would have to be qualified by whoever the attorney that presented you as the witness to be qualified. Specifically, do you have the experience to present this opinion, not fact, opinion? Because the thing is that we know that different communities may have different traditions and cultures, even within the Cherokee Nation. And so I think that's the thing where you can have opinions that differ. You may have two different Cherokee elders come in and say, well, this is the tradition, and another one come in and say, this is tradition. The court gets to take both of those into consideration. But right now, that's a may. The court may accept that.
Absolutely, I understand
And so
that.
the
But
thing-
also, when you're talking about attorneys too, two attorneys can read a case and they have two different opinions. And that's a given. That happens all the time. And that's kind of where we're at right here. I think one attorney's looking at it from one way and another attorney's looking at it from another. So we have to determine what we are going to do and do we have all the facts in front of us to make that decision whether we want to go forward or do we need to have more work done on this before we put this into effect. And I think that's where we're basically at right now. And as far as being tabled indefinitely, that doesn't mean it kills it forever. That means if you bring it back, it has to be totally changed. If it has to be changed to be brought back where it is different. It doesn't mean you kill it for all time. But I'm not saying we should do that, but I still think that, the best evidence that we could hear is prima facie evidence. I would like to have somebody from Indian Child Welfare or a representative from that department come tell us what they think about this. That's my thought.
Well, just to clarify, the only difference is right now, with using your example, is whether the other attorney is allowed to present their opinion. And that's all we're trying to do is allow that elder to present their opinion. If they don't qualify under the ICWA standard that Dora mentioned earlier, but they do qualify, the judge just say, they qualify as an elder, they just haven't taken the Indian Child Welfare classes, they haven't done all these extra things. But do we still want to hear about them on tradition and culture? The court, it's subjective. And that's the thing that we've talked about on other thing is, do we want to consistently allow our elders to testify in court, or don't we? And I think it's completely up to the council, but that's really what the purpose of this was.
I don't think that's our decision. I don't think that's our decision to say that these people have to do this. We don't. I don't. That's the court system. The court system is going to allow or it's not. What their rules are is what their rules are. And how can we change that court system on what they do, saying,
That's what the rules of civil procedure are adopted by this court. The court adopts certain rules that you guys didn't dictate.
Procedural rules, yes, sir. And that's what I mean. How can we change their procedural rules like that?
Because we have that in our code. Of course, you have criminal procedure, which is adopted by the council. You have civil procedure. And so that's exactly how you change their code.
But I think in what you're saying is then they need to be brought into the discussion too, because I want to know if that's really if you're saying what's true, if they're not letting our elders testify, then yes, we should know about that. But I haven't seen anything. I would like to hear it from them that that's the way it is, because I cannot imagine in any court system that anybody is not allowed to testify who is subpoenaed to testify. I can't see it.
And I'm not saying that they're not allowed to. I'm saying that they don't have to.
And that's up to that person, and that's up to whoever's prosecuting that case.
Did we have an instance where an elder was not allowed to?
Yes, we had an instance where an elder
in our tribal court.
In our tribal court,
Well, it's already happened.
It's already happened. It's already been there. It's already happened. And that's what this does. Is it tries to protect that. We are different than the state. We are a sovereign nation.
So it's already happened. Okay, well, that's why we're taking it back to you guys. You guys are the legal people, then bring it back to us in the right form. We'll look at it again. How's that? You had a motion, you had a second. Yeah, Councilor Lay.
Okay, so I heard the same thing, that they were not allowed to testify. But then I heard that they were allowed if they would have been qualified. That the attorney that brought the elder messed up. That's what I heard. I heard that the attorney did not present this specific witness as a expert witness, therefore they were disqualified as
Didn't meet the criteria?
Didn't meet the criteria. The attorney didn't say, I have an expert witness.
Okay.
That's what I heard.
Okay.
So that's the why.
So that, I'm like, yo, I want to hear from everybody. Why is Indian Child Welfare calling me saying this is not a good thing? Because I'm not an expert in ICW. So I want to know, why is this not a good thing? What's the negative? And that,
If there's an appropriate legislation to enhance what we're already trying to do, I'll look at it.
Exactly.
That's all I'm saying here. All right, we have a motion second. All this is taken back to the appropriate
What are we
people.
voting on?
Just
Well,
to
that's what I'm getting ready to clarify. You have a motion and a second to take it back to the AG, our council, and Indian Child Welfare, and see if they can't come up with appropriate legislation for us to look at. Bring back to us. Is that correct, Shelley?
Put it back on the agenda next month.
Yeah. Okay. All right, all in favor, signify by saying aye. All opposed? Okay. Thank you, Sarah. Thank you, Tim. All right, now you have Counselor Taylor, you want the next one?
I do. This is a resolution authorizing certain lending transactions involving Cherokee Nation businesses, Limited Liability Corporation, a Cherokee Nation Tribally Limited Company, and authorizing a limited waiver of sovereign immunity, and I put that in the form of a motion.
Second. Got a motion and a second. Any discussion? You want to add something to that?
No, I was just going to introduce the folks from C&B and just wanted to make a quick statement that I've had the opportunity, actually on several occasions, to sit with C&B and go over in detail the need for this loan and the agreements with the banks and the terms and everything, and I am in full support of this. I believe it's necessary. I believe it was well negotiated. So, but with that, I will turn it over to Mr. Evans.
You want to introduce the guy in a sports coat?
I think you guys are all familiar with him. He's been around for a while. And Miss Kim Burnett, she's the treasurer of C&B, and I think most of you are probably familiar with her.
Well, you had a motion and a second, so here we go.
Go, Doug.
You're up, Mr. Evans.
Speaker, Treasurer Scott, Council, it's a privilege to come before you again. It's been a while since I stood before this body and watched it work on behalf of people. It's good to the heart to see the continuation of this level of debate and policy setting for the advancement of the Cherokee's cause and the well-being and quality of life of all Cherokees. I have the privilege of coming before you today representing Cherokee Nation businesses, approximate 7,600 employees. Our business finds itself from time to time, as most of you know, occasionally having to resize our revolving line of credit. We're at that pace again, and being there, I have a couple of people here with me. Again, this is Miss Kim Barnett, Cherokee County original Cherokee that's been with the businesses for quite a while. I had the privilege of working with Kim back in the controller's office here back in the late 90s, early 2000s, and she's a huge asset to CMB. She's the executive director of financial services, which encompasses all of our treasury activities as well as our credit. So anything that deals with the flow of money comes through Kim's group. Also have Mr. Jim Carrington. Jim is here representing, he's the Associate General Counsel for CMB, representing our legal department. Been working on this facility, trying to get it to the point where it's ripe and primed to put before this body, which is a prerequisite before we can close, obviously, any type of pledge of credit for the Constitution. The work that's been done up to this point has been numerous meetings with a syndication group of banks that has brought us to a point where we have enough capability and capacity with the lending groups to be able to not just serve this particular request, but it was really intent on trying to set the stage with the adequate type of banks that are going to be involved with partnering with CMB for the long term. Our long-term growth strategy is going to require to move the needle both on our operational cash flows and our dividend back to the Cherokee Nation to move the needle with investment opportunities. Am I not talking loud enough?
Right.
Okay. Normally I don't even need a mic. So we've come to the point where our existing revolver is not going to be adequate predominantly and heavily influenced by the opportunity that's standing before us to the east of the Cherokee Nation. I think we all are familiar with what's going on at our adjoining state, and things continue to progress. Also, I want to give regrets. Mr. Garrett, Chuck Garrett, our CEO, would have been here today, but he had an extremely important meeting that was not going to allow him to be here today to present along with me. With that,
Is Sneago council tonight?
yes, sir, if it would be okay with your body. Mr.
It
Speaker,
would be.
we would very much appreciate it. The timing of this, waiting another month to get on a full council meeting will delay this.
Sure.
And a month that we would sure like to be considered tonight. If you guys, if this body would accommodate that, it'd be very much appreciated. We have worked the terms and conditions out with the lending group. They are very advantageous to Cherokee Nation and Cherokee Nation businesses, and I want to thank each of you for taking the time to sit down in briefing sessions where we could go over some of the intricate parts of the terms and conditions that obviously wouldn't be appropriate for discussion in this forum. But I want to thank you for taking that time, and really that's an investment of time, and it also reflects back on the commitment and dedication this body has, along with the executive branch, to enable CMB to advance the cause of what our mission in life is, economic impact and job opportunities. So with that, there are a few things that we've gone over in the briefings last week that I can reiterate in this if you want me to. There's others that I obviously can't, and I think you all understand. We've already discussed those.
Sure.
But it does increase the line from 150 to 300 million. It will give us the dry powder, if you will, to not just tackle that opportunity that's before us to our east that will move a needle with our dividend. It'll also give us enough capacity for the next one, and we can't control, nor could we control when those opportunities present themselves to CMB. As they come up, we need to be able to react and react quickly. This facility will enable us to do that. I'm happy to answer just about any question that, the ones that I'll be deflecting, but the ones that we can talk about, I'm happy to. And again, I want to thank you all for taking the time you did last week to really get into the details of this.
I think most everybody understands the importance of having the line of credit, this substantial because of your past performance and how you negotiated such a good opportunity for us with January 1st just around the corner, and with the state's mindset and the national level and everything that we could have on the table. I mean, this is a great opportunity for the tribe. We appreciate all the work that you and your staff have put into this, Doug.
Thank you, sir.
Anybody else? Councilor Taylor.
I just want a couple of points for clarification publicly. Councilor Scott referred to this as a loan. We are not going out and borrowing $300 million as soon as you leave here, correct?
Correct.
And then clarification, I asked this in a small group, but I want it on video. This is not to be used for salaries or big bonuses or any of that.
That is correct.
And then just a personal question on here. We've increased the line of credit here. Does the maturity date will now be 2024?
That is correct.
Is that correct?
It's a
Okay.
5-year term.
Right, that's all I have. Speaker.
Anybody else? Councilor Shambo.
Just real quick, I appreciate you presenting that to us, but I guess the thing that I get out of this is, you guys have always been progressive in protecting our interest and protecting our businesses. And, if we don't do this, then basically we're saying I guess the status quo is okay where we're at. We're not trying to advance, we're not trying to go back, but we also have competitors out there who in our market who are trying to better themselves. And and the only way to go forward is to do what you're doing. So you either, you're not going to stay the same because we have competition. You're either going to go backwards or you're going to go forward. So this is what we need to do to go forward and be successful.
That is correct. And as a matter of public statement and public knowledge, the dividends in the last 6, 7, 8, 9 years has gone up by about 50%. A lot of that's because we were exercising, maximizing our opportunities within the gaming market in the 14 counties. There was, during that period of time, there was significant investment in going ahead and fulfilling the entire coverage of the 14 counties for our number one competitive advantage, and that's right here in the Cherokee Nation. Now that that's essentially saturated, then we have to go outside the 14 counties if we're going to move a needle at this point and continue the growth strategy. The strategy of CNB, when it relates to growth, is very simple. How do we protect and advance at the same time? And what's needed when it comes to capital to do that? We have high aspirations of where our goals are, where we'd like to get that dividend to as soon as possible, but without enough capital accessible to us to go and execute those opportunities, we will end up in a status quo type situation if we don't get positioned right. Waiting till we build up cash reserves will take years, especially considering the wonderful investments that CNB's been able to make to the healthcare initiatives of the Cherokee Nation in the last 3, 4, 5 years. So it would be a rebuild of capital. Now, after all this, we have a significant amount of cash that's continuing to complete the funding commitment on the Mankiller Clinic rebuild, the old clinic, the medical school, as well as finishing up the large health clinic here in Tahlequah. So depleting that capital at the same time, a big opportunity in Arkansas presents itself, is what's driving the short-term need for this revolving line of credit. As Councilwoman Taylor stated, this is not a loan, this is a revolving line of credit. We use it when we want to. The reason we were able to get the terms we discussed last week is real simple. The strength of the Cherokee Nation. The physical responsibility that's exercised by this government and the prudent financial management, the lending community sees that. They witness it. Quarter after quarter report after quarter report, and every annual CAFR that gets, you guys are very familiar with the nation's annual CAFR that the Treasurer's Office puts out every single year. Those clean audits mean something to the credit facility, to the credit group. That syndication group watches us very closely. And the reason that we were able to get the terms is because of our financial strength, prowess, and prudent management. We did not borrow any of the $150 million that we had for the last 3 years, because it wasn't to our advantage to do that. But we also were able to satisfy the capital requirements of the healthcare initiatives, as well as maximize those 14 county investments within the Cherokee Nation, with the Grove property, the Coffeyville and Ramona, and the new Tahlequah Casino. So those heavy investments, we were able to stay within our cash flows to fund those. The opportunity that's going to move the needle now, we go outside the 14 counties, they can't be a $30 million investment and move a needle at all. We still will exercise our federal preemption on income taxation, but the state taxes now will come into play, and all of these other opportunities will present in some form or fashion some type of a tax on gaming revenues. So that's a
Okay, you have a motion, you have a second. All in favor, signify by saying aye. Aye. All opposed? And this will go to the council tonight. Good job.
Thank you, Speaker.
I'd like to be in your sponsor.
I do too.
2 sponsors here. 3 sponsors. 4 sponsors. 5 sponsors. Thank you, Mr. Evans. Thank you,
Council.
Oh, you did?
Okay, we have one more item agenda here before we break this up. An act establishing the Cherokee Nation Registry of Historic Places. Councilor Austin, you want to take that one?
I'd be proud to. This is an act establishing the Cherokee Nation Registry of Historic Places Act. I'd like to move for its approval and ask for it to be added to the agenda tonight.
Second. Okay, motion and a second. Yes, Councilor Coates.
I'd like to be added as a sponsor.
Taylor, you want to sponsor?
I'm already on there, but I have a question. And pardon me, I had to go blow my nose because I got to get there now.
All right, you're up.
Question was, Who do we anticipate, well, okay, there was a criminal penalties. Who do we anticipate will prosecute, what courts, and how to prosecute non-Indians?
So the criminal penalties provision was added because after we reviewed the existing law, I don't think that this area was covered as well as it should be. And so criminal actions that arise underneath this act will be prosecuted by the Attorney General's office, and it would be in the Cherokee Nation courts.
Okay, how are you going to handle non-Indians who vandalize our property?
So the criminal jurisdiction component is complicated whenever
Right.
it comes to non-Indians, and part of the way that the act is written, it has both a criminal and a civil component, which could include being convicted of a crime or a civil charge of $1,000 per occurrence. So I think that there's some room there for prosecuting civil claims. I think that it's a really fact-intensive inquiry because it's always complicated whenever you have trying to prosecute those types of issues with non-Indians. But I do think that it was drafted at least to be flexible enough to accommodate those in certain circumstances, which is the best I think we can do in that area.
I agree with you, and I'm not opposing that because there has been some vandalism, Sling Courthouse in particular. And I do think it needs to be prosecuted. I was just curious how you're going to go about that. And it sounds to me like the best with using every tool you have.
Absolutely. I think having it actually defined in the code or in this act in the way that we have gives a lot more flexibility for prosecutions, maybe on the federal level too, for non-Indians if a circumstance arose such that they would take current jurisdiction of that case.
Okay, thank you. That's all I have, Speaker.
Councilor No Fire.
I think it's a great bill. I want to be added as a sponsor, but I do have a question. How is it going to be handled for adding additional sites?
So the way that is currently drafted is the Tribal Historic Preservation officer, who is Liz Toombs, for those of you who haven't met her, works within my office. And so what we intend to do going forward, should the body approve this legislative act, is putting together a list of proposed sites to present to the principal chief for his review. It's drafted for that list and report to be submitted to this body within 60 days of the list being adopted as final for review and comment at the Culture Committee. I do think that the Speaker has the authority to change those committees if the need arises down the road. But there will be plenty of notice given to this body to review, make comments, and those lists will be drafted from our office and presented to the principal chief's office and over to the council.
Chief?
And if I could add one thing, we contemplate in this act that the public, the council will bring ideas because there's certainly sites that people know about in their areas. So we want to get that information and then have the subject matter experts look at it. When it comes to my desk, it really will be a matter of just pro forma approving it because the reliance will be on the experts. But there'll also be this period for public review and comment, which is why we built in the 60 days. So I just want to make sure that's clear. And so, Councilman, there may be areas in your district or elsewhere that you want us to consider. Please send those, and then there'll be an opportunity if you see the list and say, well, you know, this one may have been missed or I have a question. There'll be some time to talk about that.
This is a good act, Chief.
Thank you.
Okay.
And we drafted it to be flexible to accommodate multiple types of listings. So we're certainly interested to hear anything that you have, any insight and feedback that you have, and we're in the process presently of preparing a list for a review potentially early next year.
Do we want to bring that to council, I guess, or will we want to submit that whenever that happens? Before, I guess, when you're drafting a list.
So we'll prepare a report that we'll review internally, and then that will be circulated, you know, within the items that are
And that's when
regularly
we can
presented.
probably make suggestions of adding.
Yeah, and then the feedback that we receive from this body, you know, we certainly take that back and take a look at it, and all of that would have to occur 60 days before the list would actually become final. So there's plenty of time and opportunity to fully discuss each and every one of the proposed listings.
Perfect.
We're probably going to have to come back and appropriate some funds for cameras at all of our sites. It's going to get that way.
Yeah, absolutely.
That's a good problem.
Yeah.
All right. Thank you very much. We have a motion and second.
Be added as sponsor, Chair.
Sponsor? Okay. We didn't vote on it, did we? No. Okay, got a motion and second. All in favor signify by saying aye. Aye. All opposed, ayes have it. I think everybody wants to be added as sponsor. Announcements. Anybody got an announcement? If not, agiosi.